Good evening. My name is Amy Bach, and I am the executive director and one of the co-founders of the nonprofit organization United Policyholders. And through one of our three programs, the Roadmap to Recovery, I'm very pleased to bring you tonight's webinar. The webinar tonight is aimed at people who lost their homes in 2020 in two different states, Colorado and California. We understand that there may be other people with us who were impacted by the Marshall Fire or even maybe the Camp Fire, and you're more than welcome to stay. The only thing I want to caution you about for some of the recent folks is that the people who are signing on who lost their homes in 2020 are farther down the road than a lot of you who just lost a home. And so, we do want to try to, caution you that your experience is your experience, and we're here to help everyone who comes to us. But our original focus of tonight is for those 2020s. So again, please do stay with us, but just know that we do try to target our services to by year, just because of the normal progression of time. That said, people's experiences on the road to wildfire recovery have a lot in common. So even though each person's path is their own path, a lot of the issues that bring people to seek our help are similar. So we will be here giving specific answers to some of the pre-submitted questions, and then we will also be taking a limited number of questions in the Q&A, which you can use to post your questions. But we are going to answer the ones that got submitted in writing first, and then we will do our best within our goal of wrapping up in 90 minutes to try to get to everything that's in the Q&A as well. So thanks again for making the time, finding the time to be with us tonight. We're very pleased to bring you the program. So Spanish, if you want to listen to tonight's program in Spanish, you go to the control panel on your Zoom and you click that little globy icon and you pick the language. Even if you want to listen in English, you still need to pick it in order to hear everything that gets said. So if you didn't already choose your language, do that now, and we will keep going. Sure. Thank you, Karina, and thank you for helping us out tonight. We appreciate it very much. Okay, so I guess you already said that. So I believe that the slide deck for tonight did get posted on our website, and this is where you should be able to find it. We had a little last minute staff emergency, so if it is not there, I apologize, but it will be up there first thing tomorrow. So you all probably know that United Policyholders is a 501c3. We're a nonprofit like the Red Cross or the Sierra Club, but we focus on insurance. We've been doing consumer education and advocacy in the aftermath of disasters, particularly wildfires, since 1991. We don't take funding from insurance companies to maintain an independent voice, but we do our best to be experts and cultivate people who have expertise in insurance so that we can give you accurate, up-to-date, useful information related to insurance. So our team, we call Team Up, includes our professional staff. And with us tonight, we have myself and Carrie Waite and Val Brown and Eva Nguyen on tech. And then we have our previous catastrophic loss survivors who've written some of the publications you'll find on our website, and those of you who may be using our Survivor to Survivor forums, you will have met some of them. And then we have our consumer-oriented professionals that would include the two public adjusters we have with us tonight. I'll tell you about them in a minute. And then we have our government partners. And in tonight's program, we have two really important people with us from government agencies. So there you can see the staff that's on tonight's panel. Then you can see our partners. We've got Deputy Commissioner at the California Department of Insurance, Tony Signorelli. And then we have the Senior Policy Analyst at the Colorado Division of Insurance, Tracy Garceau. And we are joined by two professional volunteers, Tom Lavoie with American Claims Public Insurance Adjusters, and Robert Crown with Crown Adjusting. Tom is based in Colorado. Robert is based here in California. So we are covering both states tonight as best we can. And I just want to thank all of our experts for making time late in the day to be with us. We'll be briefly covering some educational material, but mostly trying to dig into your questions. These are the 5 main areas we will be talking about: reviewing your available limits, figuring out how much you've been paid to date in which categories, collecting every dime, and then with some focus on your loss of use ALE, and then a little bit on ordinance and law code upgrades. And then at the end of the slide deck, there are a lot of really good reference slides that Carrie Waite has put together for us for Colorado. But interspersed in the deck, you will see references to laws and regs in both states. I want to thank all these funders that are making it possible, have made it possible for us to be serving people who lost homes or who had their homes damaged in 2020. This is all the funding that that we have had since that time. Here's our 2020 California Wildfire Library on our website. Here's our 2020 Wildfires Colorado Library landing page. And then here's our Marshall Wildfire Library landing page. All these libraries have a lot of similar information, but we do put a lot of the bulletins that are unique to those fires in the library they belong in. So whatever library relates to you, that's where hopefully you'll be finding the most relevant items for you. Coming up for the Marshall folks, we've got the last class in our what we call our core curriculum, our core roadmap to recovery, where we cover the fundamentals, the most important areas, and we'll be doing a contents claim class webinar on March 30th. And you can register for that at that link. You can see our next Survivor to Survivor forums. And we are always in the process of planning our next events. So stay tuned and visit us often. A reminder, we're just here to give you information. We're not forming an attorney-client or a client public adjuster relationship here. This is an educational forum, and we're not endorsing or warranting any of the experts that are here. We've invited them to be here as educators. So just a few reminders before we dig in. As those of you know who, it being 2022 and you lost your homes in 2020, this is a process. It is not like anything you might have imagined, but it definitely takes longer than anyone would think. But you will get through it. And we know that because we have so many volunteers that have the photos to prove it. You know, the photos that show that you can get from point A, standing, you know, in the ashes, to point B, moving back into a home, and it will happen, even though it may feel like it should have happened already, or why hasn't it happened? So just a reminder why we talk so much about keeping a journal. It's because it gives you leverage. And these are just the important points that we remind you to keep writing down, because that journal, that paper trail is such an important way of helping you get to where you need to go. Just a reminder, because at our heart, we're a self-help organization advocating, educating you so that you can get what you paid for from your insurance company. So these are kind of our core negotiation points. And, we do have professionals here with us tonight, and they can tell you that, that last bullet point, avoid venting frustrations and emotions, is sort of something that's hard to say, but it's so true. Because adjusters are people, and just like anybody else, when they see a single spaced 5-page letter, like any human, especially a letter that's accusing them of being a horrible, person, their instinct, like as a person, is to not read it, right? So because we want you to get attention every step of the way, this is the guidance that we offer. So the common areas, you don't need me to tell you, not having enough insurance, valuation disputes, depreciation, whether you can recover what the insurer has held back or can't, the stress of inventory itemization requirements, disparate treatment, meaning the frustration when you hear that your neighbor got a bigger cash out than you're being offered, the logistics of buying a replacement home can be challenging, and then the chronic situation where people find themselves having rotating adjusters. I think somebody who submitted a question tonight is on number 12. And then the delays, when you think that you've made progress with your adjuster and then a new one comes along. So just a quick review. We're not going to go over this in any detail tonight, but we did do a whole program on how to figure out how much coverage you have. I'm assuming by now, the 2020s, you are pretty well aware of that, but I just want to remind you about those basics, that the base limits plus your endorsements plus your policy wording is what is the max available. And I guess I guess I should just sort of ask, I guess I can ask Tony. Tony, it's, here people are, and, quite a bit of time has passed, but does it happen that they missed a pocket of coverage somewhere, or that the adjuster missed it even this far down the line? Does that happen?
Yes, Amy, it does happen. It's not very common 2 years down the line, but it does happen. And whether it's as big as your extended replacement cost, or whether it's some smaller sublimit, it does happen.
Mm-hmm. Yeah, it really does. And a lot of what we're about at United Policyholders is just empowering the insured, right? That's one of our taglines. And that's to say that, we're all led to believe from the commercials that we see, that the adjuster's the expert, the insurance company's the expert, the agent's the expert. But we have found over the years that that very often the burden falls on you, the homeowner, to point things out to the adjuster that they may not have missed, that they may have missed. So, so this is an example of a spreadsheet that one of our volunteers donated. He modified an Excel spreadsheet, and so we offer this. It's free, and this is a good way to kind of figure out both what your limits are, but also what you've been paid. Tracy, do you want to just tell us about this bulletin? And you guys just put this out in Colorado, but it certainly should apply to people who were impacted by East Troublesome equally, right?
Yeah, thanks for having me. Welcome, everyone. I think this was written in the spirit of transparency. claims can be really confusing. And so in this bulletin, we're asking companies to be very specific with their description so that the policyholder understands what the coverage is, how it's applied, what they have to do to access it, and then when they would expect to get that. So we haven't heard too many calls about this. I think that companies are complying. So again, please just let us know if they're not.
Okay. So every once in a while in these presentations, we have you'll see one of these slides, and that's a cue to relax your shoulders so that the oxygen flows to your poor brain that's having to deal with this terminology. So figuring out how much you've been paid to date is a really it shouldn't be as hard as it is. I showed that slide that Tracy just talked about because your insurance company is supposed to tell you how much coverage is available in your policy. That's what that bulletin is about. Tony, we have sort of a corollary in California as well, I know, right? Where the insurer, there's all kinds of regs that the insurer is supposed to disclose all benefits that are available. Yes?
Yeah, that's correct. And some of the newer laws actually get even more specific, especially if you've changed adjusters, where the insurance company is required to actually give you that complete breakdown at that point in time. But that's a newer law, not so much 2020.
Yep. So, okay. But again, anything that we're talking about where you're thinking, what? The easy way to see, what other classes has UP offered on this topic is just to go to that library for your fire, and then you can go to events, and you can scroll down to see the past events, and you can see the recordings of all the workshops we've done where we talk about these things, the regs and what the insurer has to tell you. Okay, let's just jump in here. So Letitia from the California CZU fire says, we have been switched to new adjusters 10 times. How can I get the adjuster to get itemized statements so we know the exact amounts of payments? We've asked but not been successful. Tony?
Yeah, Amy, this is unfortunately, it's common. Especially over the last 5 years where there's been so many wildfires in California, at least. But there is a law in place. After 3 adjusters, the insurance company is required to give you a complete summary of your claim, which should include all the amounts that you've been paid so far and what the current status is of those coverages. If they're waiting for, let's say, a document from you or an estimate from a contractor, they should be giving you all that information. So if you're not getting that, if you didn't get it after 3, you certainly should have got it by 10. Or if you did get it after 3 and you need now an update, you should ask for it. And if you're not getting that update, feel free to come to the Department of Insurance and let us, advocate for you.
Thank you. Robert, you're a PA. I mean, it's your job, right, to figure out what the, and by the way, PA, when I say that's public adjuster, it's your job to figure out how much the client can recover. So like, what's your experience been in getting the insurer to give an accounting, let's say for a client that already got some money before you got involved? Robert, are you there? Are you on mute? You're on mute, bud. Robert.
My apology. Can you hear me? Can you hear me?
No, now we can, yes.
Sorry about that.
That's okay. But it's never happened before, ever.
So if you're coming in late, like I just did, you would ask the insurance company, if you're coming in late to advocate for your client, you would ask the insurance company to provide an updated statement of loss for all funds that have either been quantified but not acted upon. In other words, to see where the insurance company is and figure out what buckets are still available to the consumer, and to make sure that they're not getting lost in the shuffle, because too frequently they do.
Yeah. So Tom, I have a question for you out of Colorado. people talk a lot about State Farm getting a State Farm summary of loss. It seems like State Farm has their own way of producing what's sort of supposed to be like a summary document. Can you talk about, is that something that State Farm insureds should be getting automatically, or is that something you have to fight to get?
Well, yes, I think it should be automatic, but it generally doesn't happen unless we ask for it. And again, ask for something, and if you ask for it in writing. Do it by email so that you have a trail.
Mhm.
And generally, we don't get it until the end of the settlement, unless, again, we have asked for it previously.
Right. Okay.
I would add something just for a moment, just because you make a very good point about documentation. I think sometimes it's very helpful for the person doing the asking to either CC or blind copy themselves, so that you have an established timeline in your email thread that you can reflect back on. Because certainly in California, if you're communicating with the insurance company, they have essentially 15 days to get back to you and acknowledging what you've asked for.
Mhm. Okay, very good. Do we get extended coverage if we don't rebuild? Now, this was asked by a glass fire person, but this question applies equally in Colorado. So let's start with you, Tony.
Yeah, Amy, couple things. The law has always, at least for the last 20 years, has always allowed the policyholder to collect their full coverage, even if they don't rebuild and they purchase another home in another location or rebuild another location. So you have three options. You can rebuild on your current lot, rebuild on a new lot that you purchase, or purchase a new home in another location and still collect your full coverage. Unfortunately, up until about 2 years ago now, insurance companies were interpreting that differently. They weren't including some weren't including extended coverage. They were including your replacement cost coverage, but they weren't including your extended coverage, and in some cases your building code upgrade coverage and some of your other coverages. So that had to be clarified about a year or so ago. And so there is that gap in time of perhaps the 2020 fire, where some of your insurance companies were not providing the extended replacement cost coverage if you purchased in another location. Although we think the law always should have been that way, and we interpret it that way, the legislature had to go in and clarify that to make sure that it was cut and dry, and that they insurers had to do this.
Yeah. Okay. So Tracy, you know that there's a piece of legislation pending that would basically do what we have in California, which is to clarify the law to say that if you choose to replace by buying, you still get to collect your extended replacement coverage and also your code upgrade coverage if you have it. That's not the law yet in Colorado. So given that it's not clear in Colorado, how would you guys be answering this question?
We would expect those coverages to be paid. So it may not be an easy fight, but that's how we interpret the policy. Unless it's specifically excluded in the policy language that these do not apply under the purchasing somewhere else, then we would expect those to be paid. But again, that legislation is going to help us a lot, because then we'll have a law that actually says what they have to do.
Yeah. So okay, good. I know that there'll be more to say about this, guys and gals, but we're going to keep going here. Carolyn asks, I've asked for a copy of my claim related documents. They've denied me 2 times, saying the files are work product, that they won't share that information. Now, in California, there is a very clear statutory legal requirement in the California Insurance Code that says that your insurer must provide you with all claim related documents other than attorney-client privilege matters. And so without you having to hire a lawyer or file a lawsuit, that's the law in California, because we lobbied for that. So, and I'm sure Tony's agency did as well. So that is the law, but we do still hear about people saying, oh, I tried to get the report on the industrial hygienist and they won't give it to me and all that sort of thing. So so I guess I want to ask, I'm going to ask Robert this question, and then Tony. So Robert, as a routine matter, when you take on a file, a client, do you exercise this right on their behalf? Do you ask for all the claim related documents, and what's typically the insurer's response?
I do ask for anything that's going to inform how I can help my client. And I think the policyholder has a right to that information. When a claim is either, if you're addressing an adjuster that would like to think of themselves as a special investigator or an attorney, they may say that's privileged, but it's not. And you simply have to educate them that the policyholder has a right to it. So most of the time we'll get it. You don't always get it in a timely manner, but we ask for it.
So Tracy, how about out your way? I know you don't have this law. I wish that you did. We would love to help it become the law there. What do you get people asking you? I really need to see a copy of the insurer's estimate, but they won't give it to me, that kind of thing.
Yeah, we definitely get involved because we feel that they're entitled to it as well. So I'm not a lawyer and I don't do discovery, but when a complaint is filed, the division gets a lot of information. And once that investigation is closed, that record is open through the Colorado Open Records Act. So I'm not suggesting anyone bypass discovery, but if there's information that the division has obtained from the company that the consumer had a difficult time getting, once the investigation is closed, it can be revealed.
Yeah. So, Tracy, we got kind of a related question. We're talking about like, oh, this is the law in California, but it's not technically the law in Colorado. But can people, what can people do to, to avail themselves of that logical right to get information about their property that the insurance company has paid for, right? So we got a question from Bob Hunnis. So for the Marshall folks, or I'm sorry, he's troublesome. Bob is a 2020. So they're looking at some of the good stuff that y'all have been doing for the Marshall Fire and wondering, can those advances apply to us? Can we avail ourselves of those things? And it's similar. We got a similar question for you, Tony, in the Q&A from Gina, saying that the land value legislation doesn't apply. So let's start with Tracy. Can people who were hit in 2020 can they use any of the rights or the help that you've been putting into your more recent bulletins?
It's such a tough conversation, right? So I actually spoke to the commissioner today about it because a couple of the folks I worked with from East Troublesome called me when the commissioner issued that a list of asks. So his response was that, first of all, he was quite surprised that claims were still not resolved from 2020. So that was an eye opener for him, I think. And then he just shared that it would be a challenge. It was a big enough lift to get the companies to agree to some of these things for the most recent one. Mm-hmm. So it's difficult to get them to do it retroactively. And they're always worried about setting precedents. So if they did it for one who just happens to present it, but not everyone else, they could be violating, standards. So, but hearing that never has stopped me. So the folks that I handled complaints for, there was letters going out asking for it. So there's no harm in asking.
Yeah. And I think, I'm a lawyer. I, used to be a litigator. So, I always feel like, well, this is evidence. I mean, the fact that the law, even though the bulletins didn't technically apply back then, or if the law, wasn't in on the books back then, it's evidence of reason what the regulator expects of the insurers. Like, so I still think it's worth, just like Tracy said, I still think it's worth writing to the insurer and saying, under the guidance recently issued by the commissioner, you should be blah, blah, blah. And, let them come back and say, oh, well, that doesn't apply because, and because this is now and that was then, and as a lawyer, I can tell you that kind of evidence can be very helpful, in terms of your leverage and in if you were to, if you had sort of circumstances that would lead you to have to seek help from a lawyer. Tony, Gina is asking that same question about, well, okay, so the most recent legislation, we had to go back 3 times. I tell people to the legislature to tell insurers, no, we really mean it. You really have to pay them the same amount of money towards their purchase home that you would have paid them if they rebuilt. We thought we were always right. I think I heard you say earlier, Tony, that you agree, right? You guys, we were on the same page that a land value deduction was never really authorized, and that there was that they always needed to pay all the benefits that were available for a rebuild towards a purchase, but the insurers were just sort of disagreeing, correct?
Yeah, that's right. For land value, for those that aren't aware, if you go and buy a house in another location, some insurance companies, or many insurance companies up until 2 years ago, were deducting the value of the land underneath the house that you were purchasing, saying, we don't cover land, so even though you're due $500,000, the land's worth $200,000, so we're only going to give you $300,000. We didn't think that was fair, so we clarified that in the legislature about 2 years ago. But it was after the 2020 wildfires, so technically that clarification didn't exist back then. We did issue a couple of notices before that legislation kicked in, requesting insurance companies to still follow that rule. Some of them did, some of them didn't. It does become a legal interpretation issue. So while we think it's an accurate way to go and it's a reasonable thing to do, and insurance companies should never have been doing this to begin with, it's probably something, if it's still an issue, that it's probably something that needs to be dealt with in civil court.
Yeah. So yes. And so for those of you who, well, okay, so scratch that. So now we're going to get into this bigger territory of collecting full replacement cost value where available. It's related to what we were just talking about. Just a reminder, in California, that you've got this 36 months to collect your replacement value benefits. That insurers should be basing their depreciation on age and condition, not just age. And those are just a few reminders about the rules in California. But as all of you know, one of the most frustrating features that insurers have built in to the claim process as they've designed it is depreciation, and the fact that unlike that, they don't just pay you your max limits. They dribble it out, and they put you through your paces very often, which is why there are people like Tom and Robert that some people end up having to hire, and why Tony and Tracy's hotlines are pretty darn busy, because it gets confusing. How do I get all these benefits? And so this is just a sort of a refresher on how it's supposed to be. And the fact that in California, you have a legal right to know how your insurer calculated depreciation. This is just a reminder that insurers will often use shortcuts, and age is one of them, but age should not be the only thing. And then I guess I would just ask, I'm going to ask Tom, on the files that you work on in Colorado, how much of your time gets spent trying to fight for fair depreciation for your clients?
Oh yeah, that almost always comes up in the negotiations. And really our goal is to arrive at the total settlement amount up front, and at the same time show the insurance adjuster why the depreciation should be minimal. And generally speaking, we're able to get a better initial check, the ACV, from the insurance company.
Mhm. So, so thank you. So this is, a slide from another one of our classes, just sort of laying out how we recommend if you're, if you're on your own and you're doing this. It's just to understand the process, the fact that depreciation is subjective, not objective, and that you can fight for fair depreciation. Robert, why does depreciation matter if you have a replacement value policy and you're gonna get eventually everything, right? Why does depreciation matter?
Well, I wouldn't say that most people assume they're going to get it all, because until you actually replace, they're only going to pay the actual cash value loss. With that said, if you had a total loss and everything is gone, you certainly have to figure out what the cost would be were you to replace everything. If the depreciation is negotiated to some extent up front, you have less work to do down the road in keeping track of all those receipts. Because arguably, most people will not replace everything they had. If you spend 30 years in a house, your kids are out of the house, everything is still in the house, it's destroyed. It's your one opportunity to be paid fairly. And the hope would be you'd have a well-documented inventory so that you knew going in what you were intending to replace, because you'd have a need for it. And then, of course, for things that shouldn't have any depreciation, like antiques and collectibles, theoretically, you're getting the money up front. You don't have to worry about replacing it. But then you have to prove what the value of that item was.
Yep.
So it's tedious, it's time consuming, and I always, as an advocate for consumers, I'm always asking for fixed depreciation across the board, because there is a hardship associated with people having to produce receipts. Especially if you've been in the house for 50 years, you're in your mid 70s, and you're thinking, oh my God, this is going to be an enormous undertaking. So.
Okay. Thank you. So Jeannie, from the CZU fire. Okay, so this is one you heard me mention earlier, disparate treatment, fancy word there. Where some people, you hear, oh, my neighbor got maxed out on their contents, and why didn't I? Or my neighbor got a waiver of the itemization. This person got the statutorily required 30%. Looks like it took over a year before they got that. That seems
Too long.
That's way too long. And now they're on their 12th adjuster. I guess I would just say, Tony, in a situation like this, what can you say?
Well, a couple of things, Amy. You're right. I mean, if you're waiting a year and a half for your initial advance payment, that's too long. There's no up until last year, there was no statutory legal requirement to pay for an insurance company to make an advance payment. Although traditionally, the department has made requests to the insurance industry, and many of them have agreed to pay anywhere from, 50% to even some 100% of your contents without an inventory. And it was based on them voluntarily doing it, not a law. Now it's a law. They have to pay 30% of your coverage A. It gets a little complicated, but now they'll do that because they're required to do it by law. But it really depends on what insurance company you're with and the timing, like what fire it was, what year it happened, as to what they will do. If you're both, let's say, with State Farm and you had the same fire, and you have a similar situation. In other words, you didn't have it wasn't a second home. You didn't just move into the property, so maybe it wasn't necessarily all furnished. But if you're in a similar situation with the same company, you should receive the same amount. And so that's an issue that we certainly could look at. And with regard to the 12 adjusters, I spoke about this earlier, unfortunately that happens, but you should still get a summary of what's going on, at least after every 3 of what's been paid, what's not been paid, and the status of your claim.
Yeah. And so, I mean, this is the kind of sad question that is frustrating for all of us. And so, we never want to say to people, run out and hire a lawyer. And sometimes when people try to get a lawyer, that it's hard to find one anyway, if there's not enough outstanding benefits owed to kind of make it financially feasible for the lawyer to not charge you by the hour and do it on contingency. So really, this is a situation where hopefully, Jeannie, if you're with us, you have filed a complaint, you've gone on record with Tony's agency, because they do audits of how insurers are handling claims, and they have had they've issued fines against insurers for when they find patterns of slow payment. So, but like Tony said, because the law didn't actually require them to do the advance, if they didn't waive the inventory itemization and you didn't give them an inventory for that long a time, it's not right, but it may not have been illegal. So that hopefully you have filed a complaint with the department. Monty from the East Troublesome Fire asks, is our propane that they lost, is that go as part of their dwelling, or is that contents? I don't have you. I'm actually gonna hit Tom on this first, Tracy, and then you. Tom, what's the answer here?
Well, it depends where there is more room in the coverages. I might try to put it in with the coverage A, the main dwelling. But again, I don't know why it couldn't be considered other structures, pertinent structures, something like that, if there's more room in that bucket. So really, it would depend on where can we fit it in, and that's what I would negotiate.
Okay. And what about heirloom items were max depreciated unless they were over 100 years old? Have you ever seen any? That seems pretty random.
That makes no sense, because it would seem that heirloom items, being quasi antiques, shouldn't have depreciation at all. In fact, they're probably appreciating. So, and I guess it also depends on what they mean by heirloom.
Right.
Something that has emotional value to them. Well, the insurance company doesn't insure emotional value.
Yeah. Tracy, when you get presented with a situation where it seems like an adjuster is doing something arbitrary like this, what would your agency do in that situation?
Just like Tom, we look for what coverage would be best for the consumer, right? So if we can try to push the issue that it should be on A, then we'll do that. Oftentimes it's B, other structures or something. So that's what we look for first. And again, if it's not explicit in the policy, it is arbitrary, right? So we would push that issue. If it's not attached, it shouldn't be coverage A. I think, Amy, I use your analogy a lot. If you turn your house upside down and shook it, like everything come out, that's contents. And then, but I don't think propane is gonna fall out. It was such an interesting question. But
I know.
On this one, if I got it, honestly, if someone called me with this, I would say, what coverage has the most left over? What's the balance of these coverages? And that's where I would try to get them to pay it.
Right. So so Robert or Tom, both of you guys are PAs. I've always thought antiques aren't supposed to be depreciated, right? Because they get more valuable, not less. So what's going on here with that?
Well, State Farm uses uses their own interpretive vehicle for determining what's an antique. And I've heard that they base it on whether it's 100 years old or not. I absolutely disagree with that because everything has a unique value in and of itself. But age is certainly an issue for determining what the item was worth at the time of the loss.
Mhm.
If it's an antique, there shouldn't be any depreciation whatsoever. But does it if it was 99 years old and 11 and a half months, would it be less of an antique? I don't think so.
Can you make an argument that it's a collectible versus or a one of a kind because of its age or rarity? Is
Yes.
that a fair argument also?
Absolutely.
Yeah.
Without question. An example might be a client of mine whose father, who's since passed, was a well-regarded painter. Most of the oil paintings were probably anywhere from 70 to 90 years of age. I think the market, the argue of value has to do with what would something comparable sell for to a collector. And so that, that's in the realm of the subjective for sure, but you could use an art appraiser to come up with a value for something that they might have had a picture of,
Mhm.
or something comparable by another artist. So, but you have to make the argument. So,
And Amy, one other thing to add on this point is you want to be proactive if at all possible. And when you're making your list of things that you lost, contents, put in the value that it is today, put in the amount of depreciation. And then at least you've got something to start with, and then they have to, put their magic touch to it and determine what it is. But at least being proactive and putting in your numbers is the best foot forward.
Yep. So agree. We had Craig sharing in the Q&A that they got paid out for their propane tank from contents from Safeco. So thank you for that, Craig. Jeff shared regarding antique and vintage, should a claimant avoid using those words in the contents inventory? Reason I ask, I had many 100-plus-year-old items destroyed in the Creek fire in Fresno. So that's an interesting question. Why would so should a claimant avoid using those? I always thought antiques shouldn't be subject to depreciation. So if anything, I would be inclined to use those words. No, Robert?
I absolutely would. I would say arguably, especially when you're making the point of being proactive, which I think is really valuable. Part of this is your expectation of your insurer. So if you have one-of-a-kind items that are literally 100+ years old, you could say it and you could put a value on it. I think what you would use to support that value is something that is comparable through an antique dealer or a link to a website for something that is as close to what was lost as you can find. Of course, it's a non-issue if you have a picture of it. So
yeah. So somebody, Daniel Breitbach is asking, did you say, or did one of you guys just say that State Farm only considers something antique if it's over 100 years old?
I said that the experience that I've had with State Farm is that's how. I don't know if it's an industry standard or it's just what State Farm has adopted as a basis for determining what is or isn't an antique.
Mm-hmm. Tony or Tracy, has this been coming up in any of the in any complaints that have been coming into your agencies? This question of antiques.
Yeah, this is such a tough one. So in East Troublesome, a lot of those homes are forever homes, retirement homes, family homes that have a lot of unique items. So first of all, we all have to acknowledge how painful that inventory process is. But yeah, it's, because there's some adjuster that's sitting out there. One example comes to mind. So some couple spent their retirement traveling the country, picking up antiques as they went. They had antique snowshoes from, I think, the 1920s or something. And some adjuster said, oh yeah, well, you can just go to REI or some Outdoor World for $25. So there is really a disconnect between what the company sees and what really the value is. And I heard being proactive, I think that's what it is. You definitely have to know what the value of these items are and be willing to advocate for it. But there's no doubt it's very frustrating when it comes to an item that you believe carries more value, and some adjuster is just looking at some software.
Yep. Yep. So this is a classic question, right in, I'd say the top, 10 of all the problems people have. There's a huge discrepancy between I think what this person means is the valuation that the adjuster provided, including extended replacement, and the actual cost. So this person is underinsured, and they're asking, how do they collect the difference? I would say, Christina, I would really encourage you to, well, first of all, if the extended replacement cost is code for the offer that the adjuster made, and if that in fact is the maximum amount of dwelling benefits that are available to you, then your situation is you're underinsured. But if that isn't, if the extended replacement cost isn't the max, in other words, if what the adjuster has offered you isn't the max, then you need, then there are ways to break that log jam. And I've got some slides that we may have time to get to that talk about it. But Tony, bottom line, how do you guide people who have that situation?
Yeah, I mean, if your policy limits, including your extended replacement cost, is less than your contractor's estimate to rebuild, like you said, they're underinsured. In California, it's a very tough challenge. The law is not on consumer side there. The court cases have sided with insurance companies, unless the insurance company has documented, don't worry, you're fully insured, and you rely on that number they gave you, and it turns out to be wrong and too low. And so that's a tough one a hurdle to get over. We have had some success where we saw where an insurance company or an agent or broker has made a mistake in calculating your policy limit, either through square footage was too low and incorrect, or other things were mistakes and inaccuracies in the way when you applied for coverage. In those cases, we're able to get additional policy limits added to it so that more of the claim can be paid. But that's more of a rarity situation than the common situation of people just being underinsured from what their policy limits are versus how much it costs to rebuild.
Yep.
Amy?
Yeah.
For California survivors, is the same question asked of insureds who were told that they had, or at least they believe that they had sufficient coverage, but the insurance company is still unwilling to commit to the extended limit of liability because they went ahead and produced an Xactimate estimate that showed a value that was considerably less than any number of contractors' estimates that they got right out of the gate. And the only reason they're still going back and forth with the carriers because they haven't decided whether they're going to rebuild or buy, because they can't rebuild. They've been based on what people have told them, they don't have enough money to rebuild. So they can't make that commitment to go through the process if they're going to end up borrowing money anyway.
Right. Which is a great segue into this next question, sort of. Now, there's a lot of details here, and I'm not sure if we can kind of parse all of them, but the person summarized his question, Adam summarized his question by saying that they've already gotten, and this is State Farm, so while a lot of insurers, coverage B would be other structures with State Farm contents, if that's the contents bucket. So they've gotten 50%, it looks like. And they're trying to figure out whether it makes sense to keep pushing. So I guess I would start with you, Tony. Does it make sense to keep pushing?
Well, Amy, it's really a personal decision. I mean, do you want to go through the effort it's going to take to create that 100-page, 200-page list from square one, including the 50% you already got, and then seeing how far over that 50% you can go? In some cases, it's worth it. If you can come up with 80%, and even after they take some depreciation, maybe you're getting an extra 10 or 15% of your contents limit, and maybe it's worth it. If you don't think you're going to get to your 50%, or if you get to 60, 65%, but your depreciation knocks it back down to 50%, then maybe you wash, and all that effort in theory could be wasted. So it's really a decision you have to make. I would say work on your other things first, your structure and your other coverages. Focus on that, and then should you desire and have the time and just want to go through that effort down the road, and there's still time to do that based on the time frames that you have, then go ahead and attempt that at that time.
Yeah. Robert, anything to add here?
Well, I think many times, I consult with people frequently. I'm not looking to represent them. I have found many people tell me that going to the UP website and utilizing your own inventory worksheet is a great barometer for people trying to figure out, wow, the more I think about it, I'm looking at my policy limits and, just ballparking everything we had, we're already over 50% of what we're insured for. I think it is a personal decision. And, you just have to decide, especially for someone that has, collected and had a house just packed with personal property. You don't want to leave a lot of money on the table if you think you can make a convincing case for getting to within 75, 80, or even 90% of that dollar limit.
Yeah.
But going in, it's probably safe to say, and I'm not trying to monopolize the airwaves here, but if you're looking to collect 100% of $300,000, which might be what your limit is for personal property, you're probably going to have to produce an inventory at replacement that is almost double that. And only the people that know what they had would be able to gauge whether or not it's meaningful for them to try to do that.
Yeah. Okay. So Carrie, I know you've worked with a lot of people, and by the way, reminder, on the 30th of March, so about it's like 2 weeks from today, we will be offering a contents webinar, and we will have with us some experts, plus including a survivor who took a very methodical approach to doing his inventory, and then went ahead and replaced a lot of items in order to make sure he got his depreciation back. But of course, he had the good fortune to be able to have the financial wherewithal to replace a lot of things. Carrie, is there anything you want to add on this?
I just, not really. I really just want to point out that I am dropping associated links in the chat as we are talking about things. So the link to that event is right there in the chat, as well as some guidance, one of our publications on depreciation basics. And also I have put in the chat the link to the PDF for tonight, because it is up on the website currently, so you can get that right away if you would like to. As far as this exact question, I have seen many people who thought they could not reach their maximum limit and that it might not be worth it, actually take a second pass at it once they had a chance to catch their breath, perhaps from dealing with their structure, and find out that they could, in fact, get that money and not leave it on the table.
Yeah.
And with so many people being underinsured, I think it's even more important now. We also have had a number of people who have had the good fortune to be able to use competent public adjusters who are willing to just take that piece and do the contents piece, and work along with you to document your contents loss in a spreadsheet if that's a challenging part of the piece for you.
So I'm just going to hit one question that came in the Q&A, but because it's relevant. Jan Elkins asks, she says, I have coverage for offsite inventory on my policy. She was impacted by the glass fire. She struggled to complete the inventory list and still working on it. Does this type of inventory claim have a 24-month time limit? Her adjuster is being vague on how long they have that. So Tony, so this would be somebody who burned out in 2020. Does she have an argument to say she gets another year? I mean, this seems like the kind of thing where an extension, since she's making all this progress, if she sends it in partial form, what do you think? Are you on?
Okay.
There
Yeah.
you are.
Yeah, Amy, this comes up a lot, but even as far back as 2020, the law was 24 months with the ability to still collect your full replacement costs, which includes your contents coverage, but that plus 12 months for circumstances beyond your control. And that could be because maybe you didn't rebuild yet, and so therefore you didn't have the need to build your contents list yet, because you didn't have, even if you were going to build it and get paid, you wouldn't be able to replace the items anyway. And so the key is really documenting what's occurred for the first 24 months, and then more importantly, from the 24 months to 36 months, as to any delays the insurance company did, and any part of the claim that you could show that those were circumstances beyond your control, and you have good cause reason for it to go beyond the 24 months to the extra 12 months you get for circumstances beyond your control, plus you get extensions for good cause, 6 months extensions for good cause, if you can show that after that 12 months. And so it's really a matter of documenting that you have a reasonable basis to be continuing to seek these replacement costs, and whether it's a delay by the insurance company, delay in construction, that sort of thing.
Right. Okay. So this is just a reference slide. And the most important item on this one is that that D3 at the bottom, because it basically says that if there's a difference of opinion, this kind of goes to something we were talking about a little while ago. If the adjuster is saying your dwelling replacement value is X and you have a builder who's saying it's Y, then this regulation requires them to adjust and also to actually find somebody who would do the work for the price that the insurer says, which of course almost never is possible. Okay, so these are just, again, this is a reference slide for Colorado, to know what your rights are in that state. Their current, the 30%, the requirement that the insurer advance 30% of your contents limits was in force for 2020. So you have these protections in Colorado. Another reference point in Colorado is if the adjuster is giving you an estimate in an exactimate, the commissioner put out this helpful bulletin, and there you can see that his office is recognizing that insurers use estimating programs for their dwelling claim offers, but that they need to adjust the pricing for the region so that the actual conditions, and of course those of you impacted by the 2020 fires similarly had, the COVID issues with supply chain and delays and cost spikes, just like the Marshall folks are dealing with. But the commissioner in this bulletin said you've got to account for those in your estimates. Just a reminder about your leverage. And we're going to move right along here through all of these things because we want to get to every question, and this deck will be available later. Okay, how will your insurance company establish the value for the antiques I own? What defines antique? So we did talk about this a little bit. Given that I'm shopping for housewares during a pandemic, should they reimburse me for shipping expenses? Robert, do you want to start with that? And then Tom.
Well, my initial reaction would be yes, if it's an item that you would buy online, because perhaps that's the way you bought it the first time around. Frequently, though, an insurance company will actually come up with a reduced price. I mean, notwithstanding the issue of an antique, but if it's something you could buy and you like to typically go shopping for the things that you're going to purchase to furnish your home, they can't buy it in Texas if you're going to go look at it in California and buy it in California. So you would come up with a price that you feel is appropriate because that's how you purchase the items you purchase.
Yep. Tom, anything to add there on both the shipping expenses and what defines antique?
Yeah, definitely list the shipping expenses, how much it would cost to have it delivered to you, and also the tax, the sales tax on that particular item. Make sure that's all included because that is part of the cost of obtaining a replacement item.
And to the extent, and it bears mentioning that to the extent that they take depreciation, it should be on the item at replacement with shipping and with taxes, not just the value of the item. And then they depreciate it and you're stuck with a number that does not include sales tax and shipping charges.
Yeah. So, so this is a question, sadly, from a campfire person. So 2018, we did a special webinar a couple weeks ago, taxing matters for wildfire impacted households. I highly recommend that you watch it if you weren't able to tune in, because the tax, some of the tax issues around for disaster survivors are a little counterintuitive, and so it's really good to hear from CPAs that actually have had clients who've lost homes to explain it. But Carrie has done a lot of work kind of digesting, tax issues for dummies, and that's me and not you, the dummy. So Carrie, are you able to answer this at all, or should we just refer this person to the webinar?
I really am not, because there are so many nuances. And so I would leave it to the experts. And this webinar, which I'm dropping the link to, that just occurred last month, is here for you to both click on, watch the video, and also you can download the PDF. And so you can use the references. Is probably the most extensive overview of this that I've ever seen. And so I'd suggest that you do that. There just isn't a quick, simple answer to that question.
Yeah. Okay. All right. Bob from the Kincaid Fire. So he doesn't want to rebuild. And so he's trying to figure out how much the insurer owes him. And Bob, we have talked about, we talked a little bit earlier tonight about the fact that in our organization's view, the notwithstanding that it took the legislature a couple times to really to sort of close any loopholes that the insurers were trying to exploit, that they always owed you whatever they would have paid you to cover your rebuild for the as was house and up to your policy limits. They should make that same dollar amount available to purchase. And so, in our the workshop that we did a couple weeks ago on dwelling, and Carrie, if you don't mind putting a link to that in the chat, that'd be great. we went through this about how even though it can be tricky to get a builder to do a detailed enough estimate on a project they know they're not going to get hired to do, or then that one way or the other, whether it's by fixing the adjuster's estimate so it's accurate, or getting a construction estimator to help you, somehow you do have to make a good case to the insurer for what that as was rebuild cost would have been as a basis for figuring out how much you have available to you towards the purchase. Tony, is there anything you would add to that?
Well, Amy, and we touched about on this earlier, that, like you said, you should get your full cost to replace what you lost, including your any extended coverages, building code upgrade, all the way up to all those policy limits. And regardless of whether you rebuild the same home or not on your property, regardless of whether you build a new house on another lot, or regardless of whether you buy a home in another location, you should still get that same amount. However, as we talked about, the law changed 2 or 3 times since about 2018. And because of that, it's clarified now as of last year that you clearly get everything that we just described. It wasn't as clear 2 years ago and in 2019. And so it makes it a challenge other than, let's say, going to court. And I know that some consumers have gone to court, some have lost. We're not aware actually of a consumer that actually has gone to court on this issue prior to 2020 for a claim prior to 2020 and has been successful because of the fact that the law was somewhat silent on this particular issue.
Okay, that's all. Relax those shoulders. Let the oxygen flow. Okay, a little bit on you're collecting the coverage that is available to you in your policy for the cost of your home replacement project that relate to having to make upgrades to the home you used to have in order to comply with the building codes and ordinances as they are now, because you cannot get a project approved or a permit or a certificate of occupancy for a home that is not in compliance. So because policies do limit typically to what was, unless you have this extra coverage, this can be a negotiating point that can be hard. But basically, establishing what code upgrades are required is a part of that, figuring out what it would cost to put back the house you have. So Mary asks, when during the rebuild process do I ask for the money from my insurer to cover code upgrades? So Robert, I'm going to start with you answering this question.
Probably when you can prove, identify, and value the changes that are going to be required to meet code, because that is an unknown dollar amount. Insurance companies will not even address it without you making a convincing case for what codes are going to be enforced. And this is really tricky and very nuanced. And it's even hard for builders who will not want to separate out what's code to an insurance company versus what's code to them. When they give you an estimate, assuming they don't do insurance work, they're including what it's going to take to get that house built. You then have the added burden of having to separate out for the insurance company what those code costs are. So in most cases, if you're rebuilding, you would go through the permitting process. The house would be rebuilt ostensibly based on what you had.
Right.
Obviously, people are going to make changes. They're going to want to have the wherewithal to determine how best to spend the money they're entitled to. But with regard to code, you're going to have to prove to the insurance company what the code requirements are, because not all code is enforced. And again, if the building departments are going to waive a lot of the code requirements based on a FEMA declared event, it may very well be that you're trying to capture code money that the insurance companies are reluctant to pay, because they know that each district, municipality, county may treat that code requirement differently.
Okay. The insurance company is telling Sage that her well and septic are part of the dwelling, but she's way underinsured. It's unclear from this question whether she's got other structures coverage that might help. Do I need a lawyer? That, I'm gonna instead of throwing this to you, Robert, I think I'm gonna throw this to Tony. It doesn't really give us enough detail here, I think, but somebody comes to you with this level of a dispute. Would this be something where you'd say, we're not able to get to be, your advocate on the nuances? Would you send them, what would you tell Sage in this situation?
Well, I mean, first, certainly come to us. Let us take a look at it. Let us dissect the claim, see what's going on here. A couple of things I'll point out. In California, at least, recent laws are in place where you're allowed to use your other structures coverage if you're underinsured for your primary dwelling. And so in some cases, even if you are underinsured on your primary dwelling and your insurance company is trying to push something into that bucket, then you may be able to still cover it by using some of your other structures coverage. It depends on your situation of how much coverage you have for other structures and what you have there. You could be underinsured for that too. But we would like to take a look and see. We would suggest that it's probably not part of your primary structure. It's probably more other structures.
Yeah.
It might depend on where it is, maybe. But so we would make that fight initially and see where that went.
Yeah. Okay.
There is a related question from Kirsty. I don't know if that's one you want to ask Tony.
The one where
about code upgrades. We think we cannot rebuild since our insurance company said they will not renew our insurance company says they will not renew after this year. We've been paid the full amount, but not the code upgrades, and we are from CZU. So I think the question is, do you have to buy a replacement home or rebuild to capture that money? And how can you confirm that? The code upgrade money.
Well, we kind of just answered that in the but we can answer that again. I guess Tony, I guess this question kind of it combines two things. Kirsty's question. I think what she's saying, so she doesn't think she can rebuild because her insurer will not renew, meaning she wouldn't have insurance. So it's unclear, is she not, I'm not sure I get that connection between them not wanting to renew versus not being able to rebuild. I think it does go back to this question of do you have to incur it to get it? So I'm gonna throw to our PAs, I guess, that question. It's always been, and I'm gonna start with you, Tom, isn't typically insurers will say you don't get it unless you incur it, right, Tom?
Right. There are certain clauses within the policy that generally say it will be repaid, or it's a cost, must be a cost incurred by the insured. And then at that point, you can claim it. So yeah, it's a tough one.
And similar to what we were just saying about, if, I mean, I guess you need to replace, I mean, you have to replace the asset generally to get the full amount of benefits unless you're able to negotiate a cash out settlement, right? So Robert, looks like you have something you want to add.
Well, I was going to say it's even more befuddling than that. There, you do have to check the policy provisions because specifically some code upgrade will only respond to rebuilding at the lost location, not rebuilding elsewhere. I know that I think that was the case with Liberty Mutual a number of years ago, but that was back in 2017. But the policies change, all the time, but you have to start with the coverage to know whether or not you can negotiate a cash out, whether the code money actually travels should you elect to buy another lot and rebuild there. The amount of code that would be paid would be based on what you would have been entitled to at the loss location. I think it gets murkier too, because the insurance company would say, well, would the same codes apply if you bought a piece of land in Idaho, if you were moving out of state? I think arguably if the code is portable, you'll know it early on.
Yeah. So Rebecca Moeller just put something that's a share, which I think is, if I'm understanding it right, it's very helpful. She's a CZU fire. Where'd you go there, Rebecca? Hang on. A CZU fire rebuilding, and the State Farm Adjuster has in the estimate notes has specified what ordinance and law and which is included in the estimate, and specifically what code it related to, what building code that item relates to. So that, I think that's sort of a tip that for those of you who are insured by State Farm, if you can get a hold of their estimate, look in the notes and see if they've broken that out. And it's just a helpful suggestion. I know that very often your local building department will actually put up on their website, what are some of the common code upgrades that will be triggered with a total rebuild. So the next section, we have a few questions on ALE, on temporary rent, loss of use, which all those labels mean the same thing, the expenses that you're incurring from having lost the use of your home. And probably one of the most common questions we get is from people who are worrying or are already running out of their ALE before they're able to move back into a replacement dwelling. And so people are kind of looking for arguments. You've heard that there's different rules, different laws applying to different wildfire years. We know in Colorado that you were supposed to have been offered 24 months. We know that in California now you have up to 36, but that's recent law. So it's a little, I know it's a little confusing. At the end of the day, our guidance is that when you're trying to negotiate for an extension, or if your insurer is threatening to prematurely cut off your temporary rent, your ALE payments, some of your response should be detailing the things that you've been doing to keep things moving, so that you've been making reasonable progress. It's not your fault that you haven't been able to move back in. So, reasonable progress in documenting that would include explaining specifically what you've been doing to try to keep things moving, and then giving them an estimate. So, of how long you think it's going to take you. So some of the examples of the reasons that people have offered as to why they need more time are these. We did have a question, I know, in the chat in the Q&A about COVID. Tracy, are you able to share, I don't, off the top of your head, what your agency has put out in terms of telling insurers to be to be to take into account delays related to COVID?
Yeah, so, we can only push through the laws that we have. So we did issue an emergency regulation that clearly states if the company delays it anyway, we would expect them to extend that AOE. Consumers feel unprotected on that because it doesn't say if there's just a natural delay. But there was also a bulletin that asked companies to take it into consideration, what, the factors, the pressure on the resources, the competition between really good contractors. So we say just ask, right? And ask around. If you have 24 months, start asking at 20 months, right? So give yourself a couple of months to get the answer and determine whether you have to fight or not.
Yep. Tony, anything to add on that?
No, very similar in California. I mean, Commissioner Lara here in California issued a notice to insurance companies as the onset of COVID-19, advising them that they should not be enforcing deadlines and time limits that are caused by, COVID-related issues, not able to go out and do inspections, not able to get contractors to come and get estimates, that sort of thing. And most companies have lived up to that. Some have not, but that's an issue we would certainly look at.
Okay. So Jacqueline in East Troublesome is asking, how do you get in writing the fair market assessment for our monthly temporary housing rent from State Farm? We've asked and they ignore. So let's start with you, Tom, and then Tracy.
Yeah, on this one, I would also want to ask some questions up front, like, do you have actual loss sustained in your ALE coverage? Is it a second home or is it a first home? How often do you use it if it's a second home? Because all these will factor in to determining what I think she is asking. It sounds, fair market assessment of our monthly temporary housing. Well, if you're asking State Farm to tell you what the total amount they're going to pay you on ALE, you might not get that up front. It's kind of like the building departments want you to submit your plans with the code upgrades, and then they'll tell you if they're going to allow them or not. It's the same kind of thing with State Farm, where you've got to be, again, proactive and tell them what you plan to do and what it's going to cost for you to live elsewhere, which is apparently what this is, as opposed to a rental situation. And then they either approve it or disapprove it, and you might have to negotiate.
Yep. Carrie, anything you want to add on this based on your experience working with people in State Farm?
I mean, I've seen a lot of pushback recently on ALE for second homes, even if they're insured as with the same type of policy as a primary dwelling. So I'm seeing where State Farm isn't wanting to pay ALE. It's kind of what Tom was saying, unless someone is actually renting a second home to live in, say, in the area while they're rebuilding their lost second home, rather than being willing to offer or negotiate a fair market loss of use type payment.
Yeah.
Perhaps that's what they're asking for, especially difficult with the second home, I think.
Yes. Tracy, anything you wanted to add on that one?
We've been really successful with the second homes. The coverage is there. They purchase the coverage. They have access to that home. So we've been really fortunate to be able to get the denials overturned when it comes to second homes. Okay. So that was it. And for fair monthly rent, I would think that they have to give you that, how they calculated it. It's what your home could have rented for before you lost it. So there is a number there.
I'm here in California, but I'd like to ask that another question, just because especially if it was State Farm. Did the actual property owner for a second home, did they go out and rent something temporarily because they were pretty much forced to rent something in order to have it covered?
Yes, they paid for the rent locally as close as they could. And another option that State Farm did mostly, I would say the primary, they bought trailers.
Okay.
State Farm bought trailers. When you drive up to East Troublesome, you see many, many fifth wheels, and that's because of the limited availability.
Yeah, well, yeah, that makes a lot of sense. For people in California, frequently, especially if they have a portable lifestyle, what they try to do is get a valuation for the home that was damaged, that they're going to be out of temporarily or for a longer term because it's been destroyed, and try to get the insurance company to consider an allowance that would pay them fairly without them actually having to incur the expense. The State Farm takes a pretty hard line on that. You have to, like other things, you have to incur it for them to be willing and obligated to pay it.
Yep. So I obviously am falling short of my goal of getting us through this in 90 minutes. And I just want to thank everybody on the panel. So I'm just going to try to move through as quick as I can. But obviously the point is to answer people's questions. So hey, bear with us, everybody. So Celia from the Glass Fire, common complaint, right? Tony, insurer is threatening to cut off their ALE. And this, I was a little unclear about this question that they've had me make a complete list of all fabrics in the house, and I'm not quite sure what that exactly means.
I think she means soft goods. I think it's a partial loss with soft goods.
Ah, I see. Okay. So I think, and so the question is, do they have to keep paying ALE? You know, and I think this person is saying they're just doing the best that they can. And I guess it sort of gets back to this reasonable progress question is what would, you know, how would your agency see something like this, Tony?
Well, yeah, I mean, this is a common issue, whether it's a total loss or a partial loss standing home. But really, to the degree you have documentation that you're not the cause of the delay or the lack of progress being made, that gives you ammunition, and it gives us ammunition if it comes to us with the insurance company to get them to continue paying your additional living expenses. It really boils down to, were you making progress? Was it circumstances beyond your control, or are you just sitting on your hands for 6 months and still expecting additional living expenses? Usually it's the first, and you should get your ALE. It's just a question of putting it in writing to the insurance company.
So this is this one from Michael from the Glass Fire, very similar. The insurer is threatening to cut off their ALE, and yet they're stuck in the building permit process. So Tony, if this is a situation that they come to you, that this would be something you could help with?
Yeah, 100%. I mean, this is a classic example where it's beyond your control. If there's soil reports and other reports that need to be done before you get your start permit, those are classic reasons that the insurance company should be continuing to pay your additional living expense for. And I don't see any reason why an insurance company would discontinue those payments.
Okay. Is there a law in California stating that your loss of use has to be covered for 2 to 3 years? So the 36 months. So Tony, what's the current? I know it's 36 now, but was that the case for the 2020s?
Yeah, it was 24 months plus 12 months extensions for circumstances beyond your control or good cause, even up to 2020. So it's not an automatic payment for 24 months or 36 months. It's if you're making progress, as we just talked about, and if that delay beyond the 24 months is circumstances beyond your control. So again, it boils down to documenting every step of the way: insurance company delay in getting estimates or construction rebuild costs and permitting, everything we talked about. As long as you can document that those things were occurring, and that again, you were making progress, and it wasn't something that you did that delayed it for 6 months or a year or whatever it might have been, then you're still eligible for that coverage.
Okay. Um, how can I get the remaining amount of my ALE of 18,000? They say I can only use it to pay rent. Tony, you want to?
Well, yeah, I mean, we might need to know a little bit more information, but it implies here that I have money left over in my limit, let's say of $18,000. I paid for the insurance. Why isn't my insurance company reimbursing me for it? Why do I have to go through the same process that I went through for incurring the costs, submitting the bills, and getting reimbursed? We don't disagree with you, although the policy and the law don't describe it in the way that allows you to collect that money without incurring that loss of use, so to speak, and those costs on additional living expenses.
Yeah. So just a little bit of good sort of an inspiration to keep us moving in the home stretch here. An anonymous attendee wrote in, I just want to thank you all for your assistance. I've been watching your seminars since having a total loss in the Cameron Peak fire. I did escalate my claim with State Farm after having, maybe with the state, after having 12 different adjusters, and would encourage anyone that feels they are getting the runaround to do the same. Finally, I showed up on their radar. This is the point where my claim experience finally turned around. So I feel like I just wanted to share that, just because so many people feel like complaining to the Department of Insurance isn't going to help. And that was an example that is just not true. Okay, after the LNU fire, they stayed in a hotel, they moved to a rental, they've submitted receipts. And I see, this is the food one. I've been thinking about this one. Because these people had a kitchen in their rental, the insurer is saying we're not going to pay for your grocery expenses because you had grocery expenses before you had the fire. So Robert, anything to offer this person?
I'm a little perplexed by that question, in part because the insurance company wouldn't necessarily be obligated to pay continuing grocery expenses unless they couldn't sustain a similar lifestyle in the rental. So normally what a company like State Farm would do is they would try to catch you early on to determine what your normal standard of living is and what you actually pay for food. And so that if you reported that you pay approximately, between meals out and shopping, you pay almost $100 a week, and that equates to $400 a month, what they would say is, show us all your receipts for all of your food expenditures, including restaurants, and then they would review it. And clearly, if your expense is not greater than $400 a month, they don't owe you anything. So I'd be asking additional questions to determine whether or not what they're asking for is legitimate.
Okay. Ronald asks, he asked his mortgage company to send him the amount of the insurance proceeds that were above his mortgage balance, so he could at least earn interest in that. But the mortgage company, it looks like they sent him a check, but also is withholding a portion of the funds and as they to apply it toward the rebuild. So they just started their construction and they need that money. Should I return the payment so I have enough to pay my contractor? So it's unclear here whether this person has an escrow account or some sort of construction account. I'm not sure we have enough here to really be able to answer it. I guess, Tony, is there something here that you think you can address?
Well, I mean, we don't, as a Department of Insurance, we don't regulate the mortgage company, but they should be giving you, if they gave you the difference between what you owed and what the insurance payment was, that's probably what that check was. But they shouldn't be withholding the entire amount until the complete rebuild is done. They should be paying it off in installments based on phases of the rebuild. whether it's the framing, the roof, interior, et cetera. And there may be some avenues within maybe another state agency, depending on who regulates that lender, to get that mortgage company to do the right thing here.
Yep. Robert, anything to add on this?
Nothing that would be very positive with regard to lenders.
Well,
I hasten to say, and I don't want to discourage people from trying, but the banks can be just as problematic as insurance companies, where, you know, even for someone that had a fraction left on their mortgage compared to what they're owed by the insurance company, they could withhold payment until you are further along. And then that would actually create, you know, a problem for a policyholder that's looking to get enough money up front to start work.
yeah. Tracy, have you guys in Colorado been helping? Are you able to help people with situations where they're having trouble reaching somebody at their mortgage company to work with them on releasing funds?
Yes, Mike, and I apologize in advance. My dog's probably going to bark. But anyway, yes, we have this really strange statute because it talks in the statute on how the mortgage company is supposed to release the funds timely, and it sets parameters. However, we don't regulate mortgage companies, so it's an interesting statute, one that we give to consumers to advocate for themselves, right? Because they can use that statute, but we don't get complaints, honestly, on that. And if we did, we would look to see if our division of banking could help.
Okay, great. So I know there are still some questions, but we are going to have to wrap up at 7, or our interpreter has to sign off. So we're gonna speed date here. Anything that's left in the Q&A, we will do our best to answer between now and the next 5 minutes. Catherine is asking, and I think we got the same question in the chat from somebody else, that shouldn't there be a 3rd year of compensation? I think she's talking about ALE, about loss of use, temporary rent. And again, I think, you know, it doesn't, I don't think it matters that it was a federally designated disaster. The law is you get up to 3 years. And the question is going to be, as long as you're moving forward, are you making reasonable progress? You can't just, as I think we heard a couple of our panelists mention earlier, like you do have to be move. It's not automatic that your ALE will be paid. You have to be reasonably diligent in moving forward to replace the asset. How do we get paid when our adjuster ignores time limits? How can we move forward when we can't get responses? Tony, Tracy, you want to hit that?
Go ahead, Tracy.
We get paid when we ignore some time limits. Well, we don't have time limits, unfortunately, if that's what it's asking, right? So they're submitting documentation, but the company is not responding. We would look to our statute that says they have 60 days to pay or deny a claim, or they have to have interest. But there's between that submission date and 60 days, there's no regulation or statute that speaks to that. So for us, the clock would start at 60 days, which seems very excessive.
So and Carrie can, if you haven't already, she can put in the chat the link to our publication that was written by an East Troublesome Fire survivor who actually was able to get his insurer to pay penalty interest based on a slow response. Tony, we have very specific timelines in California for responding, right?
Yeah, I mean, anytime you a claimant, such as a policyholder, files or sends a communication to an insurance company, the insurance company has 15 days to respond to it. And if beyond that, it's a violation. We certainly can resolve delays. Those are fairly easy for the Department of Insurance to resolve because we can get with the management of the company and they can recognize there's a delay and there's a violation and they can resolve those issues. The harder issues are the settlement issues, but we certainly can resolve delay issues, and feel free to contact us.
Okay, here's the information for contacting the Department of Insurance. Here's the information for contacting Tracy's agency. I'm sorry, the Department of Insurance in California. Here is Colorado. We're not going to have time to go through the rest of the slides here, but they, as I said, they will be available to you on our website. These are some of the, these slides talk about mediation. California, Tony's agency has a mediation program that the legislature created. Colorado does not have it, but you can always, there's mediation in litigation. So you can learn more from us on what your options are when filing complaints with the state agency don't work, and hiring professional help doesn't work. All this stuff on your dispute resolution options you will find on our website. These are all just references for you. Again, just things, information, guidance in our library that talks about some of the issues that we got questions on tonight. A reminder that our survivor forums are a great way of getting kind of just support from people who are going through what you're going through and have gone through what you're going through. Another thank you to our funders. We had, there are just, let's see, there was one question I really wanted to answer live before we sign off. My elderly friend and neighbor in the Cameron Peak fire knew that they were not going to rebuild or replace their home back in November 2020. Because of this, the insurer stopped paying for their ALE. While they were happy to pay my rent until I bought a new home. Does this elderly friend have recourse with his insurance company? Tracy?
We would have to see what's going on, right? So what's making the company stop at ALE? So we would have to know more about the situation.
Okay, so that intent, that the fact that they said they were not going to rebuild, maybe that might have been an issue. But Tom, we've gotten some questions. If somebody is a senior citizen, is there any kind of higher standard, you know, and same for you, Tracy, in Colorado, for how you need to deal with the senior consumer?
Nothing that I'm aware of. Tracy?
No, nothing in our statute. We would expect it, right, as a protected class, but
Right.
not specifically addressed.
And I'd say, you know, as a lawyer, certainly, you know, if there's some evidence that the adjuster was taking advantage, you know, of an elderly person in the way they handled the claim, that would certainly give them leverage. If somebody was helping them, you know, if a lawyer were to help them, you know, having somebody come and say, well, you know, it feels like they exploited these folks, that can help bring about a more fair resolution. And then we had Christine, and which I have to say, I'm not entirely sure I understand this question. Underinsured, but has code upgrades. Can she get the money for remodel? I think it sounds like improvements that are voluntary. And my instinct, Robert, would you say no?
I would say it depends on the carrier, but if it was a State Farm or one of the companies that toes the line, I would say no. They
Yeah.
would not get it.
Okay, so in the 4 minutes we have left, I want to make sure that I give my most heartfelt thanks to all of you experts who are on. I hope it's been as rewarding to you as I know it is to the people that are using this service. We're so grateful. We're grateful to all of you. Carrie has put together this great deck here for those of you who are in Colorado. She has really dug into all of the regulations, the bulletins that Tracy's agency has been putting out. You will find all of these at the end of this deck. Lots of good information, lots of good answers, lots of good references. I'm going to make all of you dizzy, but I want to thank you, Carrie, for all the hard work that you do to try to keep abreast in Colorado. And then, of course, our California people are amazing. Tony, thank you so much. Robert, thank you. Tracy, you're a rock star. Tom, thank you for being part of our family. We're so grateful. Val and Eva and our translator. I'm sorry we went a full 2 hours, but obviously there's a lot of need out there, and thank you for helping us meet it. So good evening, everyone. Be safe. Get a good night's sleep if you can, and just know that I and United Policyholders Team Up are rooting for you every day and working hard to be helpful to you. So good evening.
Thank you, Amy.
Thank you.
Thanks, everyone. Now eat dinner.